Jamaica, 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 we should do better. We must do better. You know, Jamaica is known as one of those places where pedophiles are protected. Yeah, yeah. It's not a good look. Because everywhere you look, you hear people saying, yo, them boy, if dead, gunshot, this, that. But amongst them stands the same people. And even the news media in Jamaica, even after somebody has been tried, found guilty in a court of law with insurmountable amount of irrefutable evidence that they did it, the news media in Jamaica won't even show their face. You know, showing their face will allow other victims to come forward because they will say, yo, that's Mr. So-and-so that did this to me, and they have him in custody. So maybe now the police is going to do something. Let me go tell my truth too. So what it does is they hide the identity of the individuals who do these things, and then you know how the rest goes. The victims, they go quiet because they don't believe anything is going to be done, and people just are going to laugh after them anyways. Here's a story about one of these so-called people who was in a position of trust in Jamaica. Once he was accused, he ran away to the United States of America, and the story unfolds. Wilkinson, circuit judge. The person's name is Anthony White. I'm taking these from direct U.S. court papers. Anthony White, a citizen of Jamaica, was accused of molesting a young boy while he was a pastor in Jamaica. White denies these allegations and claims that the reports of the accusations that were made against him made him fear for his life, so he fled to the United States. Jamaican law enforcement authorities issued 2 arrest warrants for White, claiming that he did commit crimes of buggery and indecent assault on an underage boy. The International Criminal Police Organization, or Interpol, also circulated what is known as a red notice to locate White and return him to Jamaica. White was then detained in the United States of America as the U.S. got ready to send him back to Jamaica to face these charges. Rip off a little boy in Jamaica, hide away, ran away to the U.S. and got caught in the U.S. And he was a pastor in Jamaica, by the way. Now, during his removal proceedings, immigration ICE stuff in the U.S., White argued that he should not be returned to Jamaica for 2 reasons. For the first one, he said that he should be permitted to pursue his application for asylum and withholding of removal because he did not commit those serious non-political crimes that he is accused of. And second, the Convention Against Torture, or CAT, barred his removal because he would be tortured in Jamaica given the country's pervasive hostility towards gay individuals like himself. The immigration judge ruled against him and both counts. The Board of Immigration Appeal affirmed the judge's findings. White now petitioned this court for review, seeking to reverse the BIA's determination on whether he committed a serious non-political crime and whether the CAT bars his removal. Finding no errors in the BIA's decision, they said that we deny his petition. So I send America, did I go send him back, go back to Jamaica to face these charges, right? Anthony White, a Jamaican citizen, previously served as a pastor for a Seventh-day Adventist church in Jamaica. White is a gay man who kept his sexuality secret for fear of anti-gay hostility in Jamaica, and although he was a pastor of a Seventh-day Adventist church, he was also a homosexual. This he has admitted. In January of 2020, a young boy named J.R. came forward with allegations of sexual assault against White. The boy and his family were parishioners at the church where White had served as the pastor. J.R., the boy, told his mother, Marie Richards, that White had kissed him on his mouth in 2017 and sexually assaulted him in 2018. White tells a different story. He claims that he did not know that JR was a minor when he first met him. Administrative records, AR-16. White met JR through his church, and they grew close as White formed a relationship with Richard's family. White claims that JR and his brother would spend nights at White's house, and White began to suspect that JR was also gay. This is what he said to the court system in the United States of America. He's describing how he met the little youth. He was the pastor of the church, and he began to develop a relationship with the little youth family, with his mother. Apparently she's a single mother with multiple children. He also said that she would allow the children to come spend nights at his house, given that he's the pastor. And while they were spending nights at his house, he started realizing that JR, the little boy, was gay also. And during one of those visits, White, who is the pastor, asserts that JR, the child, made advances on him, and White claims that he rejected them. White believes that JR was about 18 at that time. Turns out he wasn't. Now, after JR told his mother, Marie, about the sexual assault, White met with Marie in January of 2020 to deny the allegations. White claims that Marie and Richard's family then attempted to extort him, demanding money, or else they would make public the accusations against him. Pay away, or we're going to tell everybody what you do. The Richards family then ostensibly began to threaten his life. White claims that JR's father, a man named Morris, sent men to White's house to kill him. According to White, his neighbor informed him that a group of men had gathered outside of his home. Later that day, White fled from his home to a hotel room, and he booked a flight to Baltimore, Maryland in the United States of America. Apparently the little boy did have a father. He came to the United States, running away from Jamaica because of this incident, on a non-immigrant visa on January 11th of 2020. He eventually resigned from that church that he was the pastor of. Very interesting that no news media house in Jamaica told anybody that this man had fled, and he was not there to stand charges. They didn't make it known to the wider public about the situation that had developed concerning. Boy, may I tell you, it's just crazy how they deal with this type of stuff in Jamaica, and the victims, they suffer a lot in the Caribbean. If you are victimized in the Caribbean, especially in Jamaica, then I don't know what to tell you your course of action should be, because it seems as if the victimizers are more protected than the victims are. Alright, let's move forward with the story now. He ran away, and he eventually resigned from that church. Obviously, he was still in contact with the people at the church, so he basically told the people at the church, look, I'm not coming back. I'm in the US, and I'm going to stay here in the US. And they agreed that he would give up his position and they would replace him, find somebody else to take his place in the church. Now, a Jamaican newspaper, the Jamaica Observer, published 4 articles in March of 2020. I want my Jamaican audience who is listening to this, or anybody in particular, you can still go look these up. Just Google them. Okay? The Jamaica Observer published 4 articles in March of 2020 describing the accusations against White. They never showed his picture, his face, or anything. Mind you, at this point, police reports were already out for him and all that. But still, as a wanted person for a serious, heinous crime against a minor, his face was nowhere to be seen. That means he could walk past anybody in public and nobody would realize that this is who was walking past them and he was wanted and how heinous his crime was. Anyways, the Jamaica Observer published 4 articles in March of 2020 describing the accusations against White. One article entitled Pervert Pastor, and it accused an unnamed, unidentified pastor of sexually assaulting a 13-year-old boy. The other articles repeated this allegation again. Through the articles, although they did not identify White by name or show his face, he claims he began receiving hundreds of death threats on social media and messaging apps. Now, we all have sense, right? If the articles did not show his face and it did not mention his name, how would people, the broader public, know that it was him so they could start giving him threats? You see, all he was trying to do was stay in the United States of America, right? So he had to use these things to tell the immigration authorities in the U.S. that because it was published in the local news in Jamaica, he was getting many death threats and he believes he would be tortured and killed if he was sent back to Jamaica, which is a lie. He would have had to face his charges. On March 9th of 2020, the Jamaican police obtained 2 arrest warrants for White. One for Buggery, the crime of engaging in anal intercourse, and one for indecent assault. According to AR 365/66, this led Interpol to issue the red notice on March 6th of 2020, or March 16th of 2020. The Interpol red notice, which is a request to law enforcement worldwide to help us please to locate this wanted person. They sought White's provisional arrest and his extradition back to Jamaica. AR 587/88. White was already in the United States by this time. He made a swift escape from Jamaica. In response to the red notice and arrest warrants, White's visa was revoked and immigration authorities detained him on March 25th of 2021. The Department of Homeland Security then issued a removal proceeding against White. In other words, they wanted to deport him to Jamaica now, but he must go through the legalities of it because he is fighting it. He is not voluntarily removing himself. In response, White applied for asylum, withholding of removal, and deferral of removal under the Convention Against Torture Act. In support of removal, Department of Homeland Security submitted 2 Jamaican arrest warrants against White. A Form I-213 documenting the chain of custody for the arrest warrant, and an investigative report prepared by a detective of the Jamaica Constabulary Force, which functions as Jamaica's police department. White objected to including this evidence, arguing that it was unreliable and untimely. The record also included the red notice from Interpol and the Jamaica Observer articles. The IJ held a hearing on the merit of White's claims in June of 2021, and though White testified in a generally credible manner, the IJ was not convinced that he was being truthful. AR 121/23, specifically, the IJ, which is the court that he went through, the immigration justice court he went through, they found that White's story that he was falsely accused of molesting JR, the young man back in Jamaica, was not persuasive against the untervailing evidence contained in the red notice, which is corroborated by articles and by an arrest warrant. AR 123. The Immigration Justice Court found that there were reasons to believe that White did commit this serious non-political crime, namely sexual assault against a minor, and that he was on the run from the consequences. Thereby, they barred the asylum and withholding of removal, and the Immigration Justice Court also denied White's deferral of removal under the CAT because White had failed to show them that he would likely be tortured in Jamaica. The Immigration Justice reasoned that White cannot establish eligibility for CAT protection by relying on mere speculations or stringing together a series of suppositions unless each step in the hypothetical chain of events would lead to his torture to be more likely than not to occur, according to AR 128. White, the pastor who is on the run, he then appealed the IJ's ruling to the Board of Immigration Appeals in January of 2022. Again, remember, I know, them hold him from 2020, right? Or he escaped from 2020 and he's been in this debacle. We are in 2022 now as you hear me going through the process. So White appealed the IJ's ruling to the Board of Immigration Appeals in January of 2022. The Board of Immigration Appeals denied his appeal and affirmed the immigration justice's decision. In other words, send him home. And he filed a timely petition for review of the BIA's decision on January 8th of 2022. On March 31st of 2022, White's final order of removal was executed. So White has since been returned to Jamaica. White now challenges the BIA decision, arguing that the BIA made an error in concluding that there were reasons to believe that White committed a serious non-political crime and that White was not entitled to deferral of removal under the CAT. When the BIA affirms and adopts an IJ, immigration justice decision, and includes its own reasons for affirming it, then we review both the BIA and the IJ's decision. This is where the court paper stopped. It says we reviewed the BIA's factual findings under the substantial evidence standard and treat them as conclusive unless any reasonable adjusters would be compelled to conclude to the contrary. We reviewed the BIA's legal conclusion called de novo, and we are bound to uphold the BIA's determination unless they are manifestly contrary to the law and an abuse of directions. Tazzy versus Hodler 660 F 3D 710 719 4th Circuit 2011 is where they took that comparison from. We first address the BIA findings that White did commit serious non-political crime, barring him from asylum and withholding of removal. The Immigration and National Act render an alien ineligible for asylum and withholding of removal if there are serious reasons for believing that that alien has committed a serious non-political crime outside of the United States prior to them arriving in the United States of America. Once the government offers evidence showing serious reasons to believe that White committed that serious non-political crime, then the burden is on White to show the U.S. authorities that these things they are saying are lies and they don't apply to him. So that's a tricky situation to find yourself in. You're running for asylum. They put out an arrest warrant on you. They turned over the evidence to the American authorities who now had him in custody, and he was unable, because according to the law in the US, you must prove that what they have said about you is a lie, and he was unable to prove that. In a similar context, the Supreme Court has instructed that any lingering uncertainty about whether the alien has met his burden is enough to defeat his application for relief. We first consider whether the agency preferred sufficient evidence establishing serious reason to believe that White committed this serious non-political crime. We then addressed whether White successfully showed the SNPC bar does not apply, and of course he failed on all levels. Our sister circuit and the BIA have interpreted the INA's serious reason for believing standards to be equivalent to probable cause. Under this standard, a court needs not find proof that the alien actually committed the alleged crime. It must only find that there is probable cause for believing that the alien had committed this crime. He ran away from Jamaica the same time he was being accused. He didn't leave before, and then later on, it wasn't like he was in the US for like a year. And later on, somebody made an accusation against him, and the accusation came out. The police report says it was a year after. He left the same time. So that gave the US authorities the reasonable doubt. Well, why would he be running like this? And how come he was okay in Jamaica in a position as a pastor at that, which means you are respected in the community and by an entire congregation, right? So why suddenly now everybody wants to kill you and you're on the run? And this is what they used to say, we're not going to buy that you need to be here and hide here kind of thing because you'll be tortured in Jamaica, right? The courts have found probable cause where the record contains such evidence of indictment, arrest warrant, red notices, and testimony from the parties involved. This is the package that the Jamaica Constabulary Force had put together and had given to the authorities, the immigration courts in the US. The IJ and the BIA here found probable cause to believe, based on record before them, that White committed these serious non-political crime when he allegedly sexually assaulted that young boy. We hold that there was ample evidence in the record to support this conclusion, namely the arrest warrants and the investigation letter and the contemporaneous newspaper articles and an Interpol red notice. First, the agency relied on 2 arrest warrants, one asserting that White did booger the little boy, JR, contrary to common law, AR 353, and another stating that White indecently assaulted JR contrary to Section 13 of the Sexual Offense Act, AR 354. The Form I-123, introduced by Department of Homeland Security, chased the chain of custody of these arrest warrants and confirmed that they were certified copies. The article, the paperwork went on and on and on. And this person, evidence against him clashes with his story. Each piece of evidence contains sufficient indicia of reliability for the immigration courts to trust its use. Both the IJ and BIA found the evidence in its totality established a consistent story that White sexually assaulted this young man while he was a pastor in Jamaica and was on the run from justice. Taken as a whole, therefore, the evidence established probable cause that White committed this serious non-political crime. Now, because the evidence indicates that one or more of the grounds for mandatory denial of the application for relief may apply, White has the burden of proving by preponderance of the evidence that such grounds do not apply. Now, White was unable to prove, given the evidence discussed above, and that White's chief objection to the evidence is that his side of the story should be believed, no other evidence, we find nothing that compels us to overturn the ruling below, as we see no merit in any of the remaining assignments of error on this issue. We shall uphold the BIA's ruling. We turn to White's final claim, and the agency erred in its determination that he was eligible for deferral of removal under the Convention Against Torture Act. So, he was ordered to be removed from the United States of America and sent back to Jamaica to face these charges. The board determined that White failed to offer evidence that the Jamaican government will torture him. We agree for all following reasons. This is what he told them. He told them the Jamaican government will torture him. He told them that people in Jamaica will torture him because he is a homosexual, not because he molested a young man and ran away. He groomed that young man, according to his story. The young man told that he kissed him first, and I'm thinking he kissed him to see if he would tell anybody. And because he didn't tell anybody, he went a step further. Now, first, White neglected to name any public officials who will likely torture him, or any person. Instead, he testifies generally that he was extorted by the police in 2016 when they found him kissing another man. This falls short of showing that the police, much less any other specific officers, will torture you. This is what he told the U.S. authorities. When they asked him, so who is going to torture you when you go back to Jamaica? He said, nobody specific, but I think the police will, because they catch me with a next man and I was kissing him and they extort me and I had to pay money for them to not do anything to me or for them to not tell the broader public. Them catch pastor kiss man. White further contended that Jamaica uses its Buggery laws to sanction violence against homosexual men, but this too fell short in the U.S. immigration courts. Reports from the Department of State shows that Jamaica enforces its Buggery laws only in cases of sexual assault and child molestation. Only. They've never used it against two grown men, two consenting adults who decide that that is what they want to do with their lives. And under AR 125/26, which is consistent with the charge here, White must therefore rely on the acquiescence theory to demonstrate likely torture. Public official acquiescence to torture when, prior to the activity constituting torture, they have awareness of such activity and thereafter breach their legal responsibility to intervene to prevent such activity. In other words, he was supposed to prove to them in the U.S. that people had gathered to torture him. Some kind of torture had taken place before in the past. He had made reports to the local authorities and nothing was done on his behalf. He was unable to prove any of this. Such awareness requires finding of either actual knowledge or willful blindness, which means that the public official acting in an official capacity was aware of a high probability of activity constituting torture and deliberately avoided learning the truth, which he was unable to prove in court, that police knew that the crowd was going to do something to him, but they did nothing about it. So White failed to offer sufficient evidence here. He claims that he witnessed two gay men in his community when all that did not work. When he told them all the things he told them and it did not work, he kept making up stories. He claimed that he witnessed two gay men in his community in Jamaica beaten and stabbed when he was a child. that his life was in danger from people on social media, and that the mob that gathered at his home, and that Jamaican officials will turn a blind eye as they harm him. And the results of these threats, because of a pervasive anti gay sentiment in Jamaica, are very true to him. Yet White's testimony neither rises to the level of a likelihood of torture at the hand of private individuals, nor to the level of showing that the government will be a part of it or act like they didn't see anything and allow him to be tortured. Despite the alleged threats on social media and messaging apps from unknown individuals and the purported mob outside his home, White could not point to any specific instances of harm that he may face, nor could he name any particular individual or groups who might want to harm him. White also does not present any evidence that he was tortured in the past. Evidence of past torture inflicted upon the applicant is relevant to whether the applicant will be tortured in the future when you are filing for one of these cases. So in other words, a guy that run away from Jamaica then, and he has some severe marks on him, like chop marks, like somebody cut up him face and cut him neck and cut him hand, and he's running for his life. When he ends up coming to the United States of America, these are one of the things that he could show to say, listen, I had to run for my life. I was getting chopped and stabbed. Take your shirt off. See my marks here. Look at my face. See how they cut my face. Look how them cut up my hand. Look how them cut me up. If I go back there, they're going to kill me. It's these kind of people that they give more likely consideration to than a person like this pastor who ran away after being accused of buggering the little 13-year-old boy. They said that his claims of likely torture thus amounts to predictions only about what will happen in the future, which we have held are factual determinations, and we leave undisturbed absent clear error. In other words, again, he won't be staying in the United States of America. The IJ and the BIA did not commit clear error in their findings. Last, though, White presents disturbing evidence of gay people being mistreated in Jamaica. He fails to link this general assertion to his individual circumstances. So what he did was he would pull up articles and he would pull up news media stuff on social media to show to them that this is how some gay people were treated in Jamaica. But the authorities in the US said, okay, we see that, but how does it apply to you? The data about Jamaica's regrettably horrible hospitality towards homosexuals is certainly relevant background information, but it does not show that White would be singled out for torture. Remember, White did not go on the run until he was accused. Information about the overall atmosphere in Jamaica, moreover, falls short of revealing actual knowledge or willful blindness on behalf of Jamaica's officials who would allegedly acquiesce in White's torture, or who would allegedly turn a blind eye in White's torture. Actual knowledge or willful blindness requires a level of specificity about the source of torture and the reaction of those in authority in response to them that is simply lacking in this record. In a sum, the BIA did not make an error, and White failed to show it was more likely than not that he would be tortured if returned to Jamaica. His petition was denied. He was sent packing back to Jamaica. So here's this. Mr. White, the pastor, was removed from the US, sent packing back to Jamaica, and the Jamaican authorities and the Jamaican news media made no one any wiser that he was back on the island. And I wonder if he was brought before a court and a case was put against him still, or if they just allowed him to melt back into the community, or maybe he ran away to another island or something. Be interesting to know what the update is. As of November 26th of 2024, White cannot be located. Leave your comments in the comment section below. Tell me what you think about this one. And I'll catch you on the next video with SoFlo TV. I'm out. Peace.